You hear the squad car door slam, gravel crunches under boots. A flashlight beam cuts through your rear window, and then the question that changes everything. Sir, do you have any weapons in the vehicle? Your heart steadies. You're a law-abiding gun owner. You're not carrying illegally, so you answer calm and honest. I do, officer. I have a legally owned firearm. That should be the end of it, but it isn't. The officer's posture shifts. His voice hardens. All right, I'm going to need you to hand that over. That moment, that exact moment, right there on the shoulder of the road, is where a routine traffic stop turns into a constitutional collision. And by the time you finish watching this, you're going to know exactly what to say, what not to do, and why the law does not require you to physically surrender a legally owned firearm just because an officer asks. Let's walk through an all-too-common scenario. This isn't pulled from a single headline. It's a composite built from the body cam footage I've watched, the clients I've sat beside in court, and the calls I get at 2 in the morning. Think of it as a mirror. A man, let's call him David, is driving home from the range, and his pistol is unloaded, secured in a case locked in the trunk. He's got his license, his registration, his concealed carry permit, even though he isn't carrying on his person. He gets stopped for a rolling stop at a deserted intersection. First contact is textbook. The officer asks for documents, and David provides them. Everything checks out. Then the officer asks if there are any firearms in the car. Davian, believing transparency is the safest path, says, yes. There's a firearm legally owned in the trunk. That's where the stop, thinking he's just being cooperative. Once Davin is standing by the rear bumper, and the officer says, I need to see the firearm. Pop the trunk. Now pause right there. If you watch enough body cam footage, it's tactress dryer up to dime. You'll notice that many people in David's position will pop the trunk without a second thought. They assume the officer has the authority to demand it, and they assume refusal will escalate things. Both assumptions are understandable, but only one of them is legally accurate. Here's the myth I want to dismantle first. If you legally possess something, you're automatically obligated to show it to a police officer on request. That is not the law. The Fourth Amendment protects you from unreasonable searches and seizures, and demanding that you physically produce a firearm, taking it from its case, handing it over, surrendering control, is a seizure of your property. The question is that seizure reasonable? Under the circumstances, the Supreme Court gave us the framework for answering that question. In Terry v. Ohio, back in 1968, an officer can briefly detain you and pat down your outer clothing if they have reasonable suspicion that you're armed and dangerous. That's the famous stop and frisk rule. It was later extended to the passenger compartment of a vehicle in Michigan v. Long, but only if the officer has reasonable suspicion that you're dangerous and may gain immediate control of a weapon. Notice what both cases have in common. The magic words are reasonable suspicion. Reasonable suspicion is not a hunch. I saw a gun case and got nervous, and it's specific, articulable facts that lead a reasonable officer to believe a particular person is both armed and presently dangerous. Simply telling a cop I have a legally owned firearm secured in my trunk does not create reasonable suspicion. It confirms lawful behavior. The officer knows where the gun is. He knows it's inaccessible to you while you're standing outside the car. There's no immediate threat, no furtive movement, no bulge in the waistband, no match with a suspect description. The demand to see the weapon under those facts is a warrantless seizure that a court would very likely find unreasonable. And that brings me to a mistake I see over and over. One that can turn an innocent encounter into an evidence-gathering fishing expedition. Didn't know he could say no. He assumed that once the officer said, "I need to see the firearm," he had no choice. But the law says you absolutely do have a choice. Consent must be voluntary, not the product of coercion or a show of authority. If you unlock your trunk because you feel you have to try, a prosecutor might later argue you consented. But if you calmly and clearly assert your right not to hand over your property, you've changed the legal landscape. You've put the officer in a position where he must either justify a warrantless seizure, actual reasonable suspicion, or back off. So let me give you the exact words to say, the phrase you can keep in your back pocket for that precise moment. It's built around the Fourth Amendment's protection against unreasonable seizure of property, and it's distinct from the more familiar "I don't consent to a search." When the officer says, "Hand over the firearm," you look him in the eye. Keep your hands visible and say this: "Officer, I do not consent to you taking my firearm." That's it. Clear, polite, non-confrontational. You are not resisting. You are not refusing to identify yourself or comply with lawful orders. You are asserting your constitutional right not to have your property seized without a warrant, or an exception to the warrant requirement, and you're creating a record, whether through the officer's body cam or your own dash cam, that will matter immensely later if the stop turns into an arrest or a drawn-out detention. Now I want to slow down and walk you through the rest of David's encounter, beat by beat, because the legal ground shifts fast, and most people don't realize where the new dangers are hiding. When David hesitates, the officer says, "Sir, you told me there's a gun in the car. I need to secure it for my safety while I finish this stop can. Please pop the trunk." Notice the rhetorical move here. The officer is reframing the demand as a safety measure. Clever, implying that the mere existence of a firearm, even one lawfully stored and out of reach, creates an ongoing threat that justifies the seizure annus. But it's legally hollow. Remember Terry officer safety alone, without reasonable suspicion that the person is dangerous, does not authorize a search or seizure beyond a brief pat-down for weapons on the person. The Supreme Court in Arizona v. Johnson clarified that a traffic stop does not automatically grant an officer the right to search the vehicle for weapons, just because a weapon might be inside. The officer must have particularized suspicion that the occupant is dangerous and may gain access to the contraband. A firearm stored in a trunk with the driver outside the vehicle and compliant does not present the kind of immediate accessible threat that Michigan v. Long was designed to address. This is the moment where David's story could have gone in a completely different direction. If he had said, "Officer, I do not consent to you taking my firearm," the stop might have remained a civil conversation about the rolling stop. Instead, Davrin defaulted to what felt like de-escalation. He opened the trunk. He retrieved the case at the officer's instruction and handed it over. In doing so, he inadvertently gave the officer a new set of facts to work with. The officer unzipped the case, removed the pistol, checked the serial number, and you can hear it on the body cam audio. "Is this your only item?"
"Yes."
The officer ran the serial. It came back clean, but then the officer, now holding the gun in his hands, said, "I'm going to hang on to this while I write your citation. You'll get it back when we're done." That's a seizure. And because David voluntarily handed over the firearm, a court might view the initial transfer as consensual, even though it was prompted by a command. But the continued retention of the firearm, after the officer confirmed it was lawfully owned and not stolen, that's a new independent seizure that requires its own justification. And without reasonable suspicion of a crime, that retention becomes unreasonable. Here's the second myth I see on forums and comment sections. If you've got nothing to hide, Just cooperate. I've stood next to clients who had nothing to hide and still ended up in handcuffs because cooperation blurred into waiver. You can be fully cooperative, provide your license and registration, sir, whether there's a firearm in the vehicle. In most states, you are not required to volunteer that information unless specifically asked. But if asked, you may answer truthfully without automatically waiving your rights and still decline to physically surrender your property. The right against unreasonable seizure does not disappear because you're a law-abiding citizen. It exists because you're a law-abiding citizen who should not have to prove your innocence by handing over your possessions. I want to pause here and plant a flag on a crucial legal distinction that often gets muddied. There's a difference between the officer seeing the firearm and the officer taking the firearm. If during a lawful traffic stop, a firearm is in plain view, sitting on the passenger seat, the officer may be able to secure it temporarily under the plain view doctrine and officer safety principles, depending on the jurisdiction. Some circuit courts have allowed a brief seizure of a visible firearm to neutralize any immediate threat. But when the firearm is not in plain view, when the officer has to ask you to retrieve it and hand it over, the dynamics change entirely. You are now an active participant in the seizure, and you have the right to decline that participation. That's why the phrase, "I do not consent to you taking my firearm," is so powerful, Ted. It draws a bright legal line between passive presence and compelled production. Now let's get practical, because theory only helps if you know what to do. When your heart is pounding and the strobe lights are painting your rearview mirror red and blue, first, know your state's laws on duty to inform. Some states require you to immediately disclose the presence of a firearm if you're carrying concealed. Others do not. If you're legally required to inform, do so. But understand that informing an officer you have a firearm is not the same as agreeing to hand it over. The obligation is typically to disclose, not to surrender. Second, if you choose to disclose when not required, keep your words precise. Officer, for both of our safety, I want to let you know there is a legally owned firearm in my trunk, secured in a case. I am not reaching for it. That statement accomplishes transparency while proactively reducing the perceived threat. It also sets the stage for your refusal to produce it if asked. Third, if the demand comes anyway, your response is the phrase I gave you. Officer, I do not consent to you taking my firearm. And say it once, calmly.
Calmly.
Do not argue. Do not raise your voice. If the officer repeats the demand, you can ask the question that often clarifies whether this is a consensual encounter or a detention. Am I being detained or am I free to go back? This is a separate right, the right to know the nature of the stop. It comes from the Fourth Amendment's protection against unreasonable seizures of the person and enforces the officer to articulate whether he has enough suspicion to escalate the stop beyond the original traffic infraction. These two tools, the seizure objection and the detention challenge, work together to create a record that any defense attorney can use later. What if the officer ignores you and takes the firearm anyway? The body cam is rolling. Your refusal is recorded. That footage becomes the cornerstone of a motion to suppress. If you're charged with anything, and it can form the basis of a civil rights complaint if the officer acts outside the law. Courts have repeatedly held that the Fourth Amendment is not a suggestion, and that officers who seize property without reasonable suspicion or consent violate clearly established rights. In United States v. Place, the Supreme Court made clear that a seizure of property occurs when there is some meaningful interference with an individual's possessory interests. Taking your firearm out of your hands and walking away with it certainly qualifies. The officer claims he's taking the gun for officer safety until the stop is over. I've seen this move used as a workaround. The argument goes, it's not an investigative seizure, it's a temporary safety measure. But even a temporary safety seizure must be justified by specific, articulable facts, and it must be no more intrusive than necessary. If the gun is already locked in the trunk and you are standing outside the vehicle, the intrusion of opening the trunk, retrieving the case, and removing the firearm is far from minimal. Courts have rejected the officer's safety blanket justification in those exact circumstances, noting that a truly safety-minded officer would simply ask you to remain outside the vehicle, not insist on physically possessing the weapon. So here's your takeaway. The rule you can write down and rehearse until it becomes second nature. The police can ask if you have a firearm. They can even ask to see it. But in the absence of reasonable suspicion that you're involved in criminal activity and that you're armed and dangerous, they cannot compel you to physically produce it. And you have the right to say no. Knowing that right doesn't make you anti-police. It makes you a person who understands that the Constitution doesn't take a back seat just because a traffic stop gets tense. The founding document didn't come with an asterisk. Except when you're nervous on the side of the interstate, your rights are strongest exactly when the pressure is highest. Now, what happens when the officer isn't asking about a firearm, but is asking to search your entire vehicle? That opens up a different Fourth Amendment landscape. One where the phrase, "I do not consent to a search," finally becomes the star of the show. And there's a body cam video. I want to break down next a stop that begins with a burned-out taillight and ends with a federal lawsuit. That's a conversation for our next sit-down.